and by the entrepreneur. Its vision is to connect rising entrepreneurs with seasoned innovators and leaders and create value in communities. This is done through 5 pillars, namely networking, mentoring, education, incubation, and funding. TIE was founded in 1992 in the Silicon Valley by successful entrepreneurs, corporate executives, and senior professionals. Today, there are more than 12,000 members and over 1,800 charter members in 61 chapters in 12 countries. The Bangalore chapter was founded in 1999 and has been taking the TIE mission forward ever since. If you need further information about TIE, if you're not a member yet, or you're a member and you want to know more about awesome sessions like this and other special interest groups, please do not hesitate to contact the TIE members. I request Vinay Dora from TIE to please put the information on chat so that our participants can connect with you as needed. Okay, thank you. Now, coming to the topic at hand. So we are here to learn more about what is being termed as one of the most important pieces of legislation in the history of India, the Digital Personal Data Protection Act 2023. The DPDP Act is a culmination of years of effort by the government, industry, and data privacy experts. To be precise, almost 10 to 12 years. When Aadhaar came in 2009, there was a huge cry about data privacy concern and why we were bringing Aadhaar without a proper data protection legislation. But of course, at that point, the UID was the priority. The Doraswamy judgment of the Supreme Court changed the country's focus to make right to privacy a fundamental right. And the Justice Sri Krishna Committee was created since then began many versions of the Act, many versions of the data protection legislation in India, culminating with what we have now, the DPDP Act. The Act has received the President's approval and the implementation is awaited. We'll hear more from the panelists. What is the Act about? Who does it apply to? How are businesses going to be affected? How does it balance seemingly conflicting interests? The interest of individuals' right to their protection of their privacy and personal data, and the need to gather data, which is the new oil by the businesses. I'm Roopa Doraswamy, co-founder of flywork.io, and I'm also a TIE Charter member for a long time of TIE Bangalore. And I'm the moderator of the session. I have a big welcome to all our very distinguished speakers in today's session here. The way I'm going to do it, I'm going to introduce each of them right now, and then we'll go into the Q&A. Introducing Sharda. Sharda Balaji is the founder of NovoJuris, a full-service law firm. It's a new age corporate law firm based in Bangalore and beyond. And they work with startups, including fintech, right to multinationals. Over the past 15 years since founding of her firm, she's been assisting clients through all phases of their growth and with very, very, very complex issues, including data privacy and compliance. In addition to being a lawyer, she's also a company secretary, and she has been a very active TIE Bangalore charter member. Thank you so much, Sharda, for joining us.
Pleasure.
Next, we have Stephen Mathias. He is the senior resident partner in the Bangalore office of Kochhar and Company, a leading law firm in India. He co-chairs the firm's technology practice. Stephen is an expert on data and has advised numerous banks and financial service companies on data protection issues in India, both for their Indian operations and their offshore support centers. He assists many clients in providing Indian law inputs for their multi-country review of data privacy aspects of new business practices. Stephen is a graduate of the National Law School of India, University Bangalore, and he is also a TIE Bangalore charter member. Welcome, Stephen. Now we come to the other guy. Abilash Soundararajan is the founder and CEO of PrivaSapien. The reason I said other guy is because he's the only techie in our panel. So welcome, Abilash, for daring to come here and speak amidst us. PrivaSapien is the world's first unified privacy engineering platform that helps businesses visualize privacy risk, simulate privacy attacks, and mitigate privacy risk for data collaboration and analytics. Abilash has over 18 years of experience working across industry like networking, cybersecurity, blockchain, IoT, artificial intelligence, privacy, etc. He has filed more than 30 patents and is an alumnus of IIM Bangalore. Welcome, Abilash. So, thank you. Abilash, you're on mute. If you can unmute yourself, that way the whole thing goes.
Thank you so much for having me.
No problem. As you can see, we have a distinguished panelist here, and welcome all the participants too. I'm going to throw open the first question immediately to Stephen. Stephen, I request you to first set the context for us. What is the status of the Act now? Who does the law apply to? And what are the requirements of the law? Just give us like a big picture, high-level presentation, set the context so that we can go in further detail. Thank you.
Sure. I had a small presentation. Are you able to see it?
Yes, you can put it in slide mode though.
Great. So to answer the beginning of your question, the law was passed by both houses of parliament. It was approved by the president. But after that, it needs to be notified by the government, and the government will notify when the law will come into force. Initially, the minister had mentioned between 6 months to 10 months, but just a few days ago, he said it is more likely to be 6 months. But he did say that after they appoint the Data Protection Board, then they would start some discussions with stakeholders to arrive at a final gestation period. But as of now, it seems likely it'll come into force in about 6 months from now. So to take you through the basics of this law, first to understand there are really three parties involved. There's the data fiduciary, that's the party that collects the data, decides how the data should be used. There's the data processor who may process the data on behalf of the data fiduciary. And then there's the data principal, that's the individual whose personal data is involved. There are some other entities involved, covered by the law. What is personal data, which I'll refer to through this presentation as PI? It's any data about an individual who is identifiable by or in relation to such data. So if that data identifies that individual, then that is called personal data. It's a very wide term. I have largely found from a global perspective, there are really three types of situations. One is where there's personal data of individuals that's processed in India. The law will apply completely to that. Then there's personal information of individuals that's processed outside India, say an overseas business that may do some offerings of goods or services to someone in India. If they offer those goods and services to a person in India, then they would also be covered by the law. The key word here is offer, and we're still not really sure exactly what that means. And then you have personal information of individuals outside India that's processed in India. And here I'm referring largely to the large offshore and outsourcing industry in India that processes personal information of non-Indians. By and large, the law is not applicable here. There are a few provisions that are applicable. So, the whole basic, the basis of privacy legislation is really what's your ground for processing personal data. And there are really three situations. There's consent. Consent is the main ground. Then there are some situations which the law covers where consent is not required. And then there are some exemptions where particular situations a large part of the law is not exempt. Do understand even the situations where consent is not required, some of the key provisions of the law don't apply there too. What is consent? So obviously consent is where you write to someone and say, can I process your personal information, and can I process it for these purposes? That consent must be freely given, it must be specific, it must be informed, it must be unconditional. There must be an unambiguous indication of consent in a clear affirmative action. This language is very similar to GDPR, except for the word unconditional. And GDPR actually applies very strict standard as to what consent means. So generally under contract law, if you say, I will use your personal information for X, Y, and Z, you have a right to accept my privacy policy or not accept it. If you don't accept it, you don't need to take my service. That would be consent in most situations under contract law. Under GDPR, that would not be consent because you don't have a choice there. So here you would probably distinguish between purposes that are absolutely required in order to provide the function of the service and uh, purposes which may not be required, but where you might want it, say for performing analytics and so on. So in the former case, it's very likely it would be considered free consent. But in the latter case, if you don't give the option to the person and say you can opt whether to give consent or not give consent, then that also would not be consent. You need to give that option. And it's possible a person may say, I don't give my consent, in which case you can't use the personal data, personal information for that purpose. Where is consent not required? There are a bunch of situations which the law covers. The first one is where it's given voluntarily by the data principal, and there's no indication from the data principal that the consent, that he's not giving consent. It's a bit unclear what voluntarily means here, but by and large, my understanding is a situation where the data principal gives the personal information on her own initiative. Then you have, obvious situations like compliance with law, compliance with court orders, government power with regard to subsidies, integrity and sovereignty of India, protection of security of state, and so on. You also have medical emergencies, epidemics, government power again on public order. And then there's an interesting one on employment. So by and large, you don't need to obtain consent where it's a situation of employment. Not every purpose for which an employer use personal information may be covered in this scenario. One would need to check, but by and large, for typical purposes of employment, you would not need to obtain consent. Then you have a bunch of exemptions where most of the law is not applicable. So this would be enforcement of a legal right or claim, functions of courts, and also certain bodies that have supervisory and regulatory powers, preventing or investigating offenses, M&A transactions where one party may have obtained the personal information, but that party is being, say, merged into another party, then automatically that other party would also have a right to that personal information. And then there are situations of financial default. So all of these are covered under exemptions, and a large part of the law is not applicable here. What do you need to do? So the first thing you need to do is you need to send a notice to the principal, data principal. You need to tell the data principal what personal information you're collecting, what's the purpose of processing that personal information. You need to give them the ability to revoke the consent, and in the same or as easy a manner as when they gave the consent. And then you need to inform them what is the procedure for grievances, and also grievances in appeal to the Data Protection Board. This is essentially what's covered in the notice that you have to send to the data principal. Do keep in mind again here, when we talk about free consent and when we talk about specific consent, what that really means is that you will have to list each process separately, and very likely you will need to obtain consent for each process separately. So your notice can't just have very general purposes of what you want to use the personal information for. The purposes need to be mentioned specifically. There are some key rights that the data principal has. These apply where consent is given or where the personal information has been given voluntarily. So right to access. you can write to the data fiduciary and say, I want to know what personal information of mine you have. If you find the personal information is incorrect, you can ask for it to be corrected. If it's become outdated, let's say you've changed your address and you can ask them to update it. And you also have a right to ask them to delete your personal information. When does that occur? By and large, it occurs in three situations. One is you can revoke your consents. You've given consent to use your personal information for a particular purpose. You can revoke it. The second would be where you ask for a deletion that I just covered. And the third is quite important. The data fiduciary on its own is required to delete personal information. There are different grounds mentioned for these three scenarios, but by and large, the overriding ground here is where the purpose for which it was collected is no longer served. If you collect it for a particular purpose, you don't need it for that purpose anymore, then these three situations could arise. I'll just one general point here with regard to the rights of data principles. It's very important for a data fiduciary to have the systems in place right from the time you collect personal information to be able to manage that personal information, know where it is, know what it's being used for. Because if someone comes and asks you, what do you have of mine? What are you using it for? I need it to be corrected or I need to be deleted. You should be able to manage that personal information. The law is slightly different for children. A child is defined as someone below 18 years. You need verifiable consent from the parent. The law does not allow tracking and behavioral monitoring of children, though the government may allow it in some cases, because the reality is that there are children using the internet below 18 years, and there is some amount of behavioral, or shall I say, targeted advertising and so on to them. A bunch of key issues that I would just highlight. As a data fiduciary, you need to have a grievance procedure in place. You need to appoint a person to oversee grievances. The personal information, if you're using it to take a decision about the data principle, it needs to be complete, accurate, and consistent. All data breaches need to be reported to the Data Protection Board of India and to every concerned data principal. It's a very strict standard. There is something called a significant data fiduciary, and they are largely going to be very large data fiduciaries. They have to conduct data audits and data impact assessments. The government will notify what exactly is required. You need to maintain reasonable security safeguards. You cannot transfer personal information to countries that are on a negative list that the government will notify. If you use a data processor, you need to have a contract with the data processor. And the indication is from the law that you'll be liable for any defaults by the data processor. So that agreement and the indemnity you'll ask for from the data processor would be very important. And do note, there's a schedule of penalties. The maximum penalty which applies where you do not use reasonable security safeguards is as much as 250 crores. That's the basics of this law. And I think we'll move forward and understand more detailed aspects now.
Thank you very much, Stephen. That gives us all a good context to go forward. Now, we already have questions. So, I'm just going to pick a couple of questions. And Sharda, if you can answer them, that'll be great. One of the questions here, I'm just going to switch between the lawyers first, Abilash. Just wait for a minute. We're going to come to the tech questions. And I know Sharda has to go a little early, so I'm just taking the best out of her as much as I can. So, Sharda, if the consent is denied by a data principal, then does the data fiduciary have the option to deny that service to the data principal? You're on mute, Sharda.
So the data principal takes sole responsibility if they don't give the consent. So as a result of not consenting to something, they cannot get the service. So the data principal is solely responsible. If she wants to receive the service, then she has to consent.
Okay. And just to give a context, guys, we're using all these big terms. I know Stephen says, so all of us could be data principals, correct? And most of us, many of us here could be data fiduciaries. Some of us here could be data processors. Because if this is a TIE network, all of you are doing probably some startup or the other. So it's your own data. You're the one gathering the data. So that's just the context. And Sharda, one more question on data principal. If the data principal revokes the consent, does that automatically delete the PI, or should we do it explicitly?
So there are two options. So the data fiduciary and the data processor will have to either delete or anonymize it. Therefore, when you anonymize, it doesn't get linked to the data principal set, right? So they can do either of them.
Okay. Okay, great. So coming back to Stephen for one question, because I want to touch upon GDPR. There's a lot of questions here on GDPR. And I know Stephen spoke about it. So Stephen, just one line about how different our law is from the European GDPR. And I know in one of your sessions, you were talking about a disappointment that our law may not apply to outsourcing processors. So just a quick thing about that. You can just...
Sure. So two broad points. One is that the law is not as detailed and not as comprehensive as GDPR. So as a result, when you go through this law, you will find all over the place that there are differences between the law and GDPR. The second one is, and as a result, the requirements also for a data fiduciary are far less than they are under GDPR. But the other aspect is that there are some provisions which are stricter than under GDPR. So one of them is legitimate interest, the concept of legitimate interest, which is that under GDPR, I don't need consent if I can show that I have a legitimate interest to use personal data. Now, the standards of obtaining consent are very high under GDPR, and it's quite hard to obtain consent in the way in which consent is structured in GDPR. And the same language is used in this statute as well. So the lack of a legitimate interest ground is a big issue. And if we interpret consent in the same way as we do under GDPR, the law could become very hard to be workable for data fiduciaries. That's one big difference. Another big difference is that under GDPR, data breaches are required to be notified to the relevant data protection authority or the data subject only in situations where there's a risk to the rights of the data principal. Whereas here, it is required in every single case. So even a small accidental data breach that compromises the availability or the integrity of the data, that will need to be notified. That's a very strict standard. So those are a couple of examples I would cite where the law is actually stricter than GDPR.
Super. So let me circle back to you. Sharda, quick question for you about, because there's so many startups here, and I know you're the queen of the startup community, legal, you've been working with a lot of startups over the last several years. I know that Stephen spoke about, some of the aspects of, I know the entire legislation is about the individual and individual's data. But many of our participants as businesses, they have to run their business. They need that oil. Stephen briefly spoke about consent, legitimate use. Can you just tell us a little more about it, and specifically how are startups and small businesses going to be affected by this? And what is your advice?
Oh, it's big cost, first of all.
And also and a little bit on employment. There is one question here about gig economy and whether the gig economy players are employees. That's an interesting question. Finish what you have to say, and then if you can touch upon that, that'll be great.
Sure. I think Stephen kind of covered consent. I'll skip that. There's consent revocation. We spoke about that very briefly. If a data principal requests for withdraws consent, then the service also gets impacted. There's one point that I wanted to add to Stephen's point is if the consent was obtained prior to this act, and we are yet to know when the act gets notified, the data fiduciary should notify the data principal about processing of data based on the previous consent. But we'll have to wait for the rules if there's any additional requirement. So that's one tiny additional point. And there's also this consent manager, a concept that the DPDP Act has, which is more like a single point of platformish, where the consent manager provides a platform for accessible, transparent, interoperable for managing all the consents in one place. And one of the relevant one that we could talk about is Niti Aayog's DEPA, based on which the account aggregator platform works on. So that's one additional point that I wanted to point out. Legitimate use is one of it, and the main point that I wanted to touch upon is the employment related, where there are several processes that an employer does. The employer collects a bank account for processing salary, biometrics for entry and exit from the premises, insurance policy, corporate wellness, etc. Now, this falls under the legitimate use. What legitimate use means that you don't have to take express consent to provide some of those services. Now, an employment related, based on maintaining confidentiality or protect employers' loss or liability, or protecting intellectual property, then it is considered legitimate use and no express consent is required to process the employee's personal data. So that's one big sort of a relief for the employers. Some of the exemptions that Stephen touched upon is listed out here. Now, many of the exemptions are granted to government agencies for processing, and that itself is a big topic to speak about. And there is some grouse by many in the country that, how can you exempt? So that sweeping exemption granted to the government, that's another topic to talk about. And here is something that we need to talk, right? Especially for startups. Now, what it means is based on, so there are certain exemptions granted based on the volume and nature of personal data processed. Now, volume is not defined. Nature is not defined. So a lot of detail that is required in the act is not there. It might come in the rules is the hope. And we sincerely hope the rules are a lot more detail oriented and comprehensive. There are, like the government and certain data fiduciary and a class of data fiduciary are exempt, and including startups. Now, startups, what it says is means recognized under the extant law. Now, we have the Startup India program where the startups get registered under DPIIT. Perhaps, it's only a perhaps, that is what they mean by it. And also, the exemption is provided for a certain period of time. That's how the Act envisages. Now, what are these exemptions? The notice that Stephen touched upon on, how, why, what, how processed, who are you sharing it with, etc. Kind of a notice might be exempted if this rule comes in greater detail, and there are a couple of sections where personal data is used to make a decision affecting the data principle or disclosed to ensure completeness, accuracy, and consistency. That's an exemption. So I really would like to see the detail of how they can just carve out only this part of it. And the retention of data for compliance of law, of course, we need to retain it. But can it be, how do you retain it? That which was the previous question. Can you, it can either be erased upon data principles withdrawal of consent, or you anonymize it, right? And there are additional obligations for significant data fiduciary, and that's an exemption based on the volume, the sensitivity, the risks, the impact on integrity of India, electoral democracy, etc. Now, there's also the whole section of Section 10 is exempt, which is an appointment of a DPO to represent the significant data fiduciary as the point of contact for a grievance redressal. Periodic data protection impact assessments are some of the exemptions. And also, if the exemption comes, right, the data principal's right to access information about personal data, the summary of data processed by data fiduciary, or identifying who has it, along with the description so shared, can be an exemption that we can expect. Now, having said that, we still do not know when the Act gets notified. So there is, of course, a period of preparation for each of the companies, startups, DFs, DPs, data processors. And also, I think it is good to get started in the direction that is available, including the tech architecture, which I hope Abilash covers. But is there a very grand exemption available for startups? No, I don't think that's possible.
And when you say startup, I mean, we can also say MSMEs, or we don't know, right, the definition of startups right now.
We still do not know.
We still don't know. So that is one of the questions here. So there are tons of questions here, but I'm going to, how much time do you have, Sharda? I know you have to leave early, because if you want to talk about breach, because everybody is asking, what is it? I mean, what am I going to be liable for? All this is great. You're protecting my data. All these actors and players have been introduced, but what do I need to do to get, pulled up under this Act? You want to speak about this, then we'll move to Abilash after that.
Good. So, it's a big one, right? Heavy, hefty penalties. Now, what is personal data breach? Means it's a definition, right? And it's a broad one. It's unauthorized processing, accidental disclosure, acquisition, sharing, use, alteration, destruction, loss of access of personal data, where there's a compromise of the confidentiality, integrity, and availability of personal data. So that's the definition. I've copy pasted that. It's a broad definition. So even minor breaches of this, even if there's no impact to the data principle, has to be reported. So there's no materiality threshold, nor is there a sensitivity threshold.
So that's a little different from the current law, I think. The current law, you have to show some kind of, the principal equivalent had to be affected in some way or the other. You had to show something. So this is a little different here, where just the breach is enough. That's what I've, yeah.
And also we need to expect what comes out in the rules as the format, method, and the granularity required for it. Now, the DF, the data fiduciary, should promptly inform every affected data principal and the board. And the time is not mandated here, right? And it again the detail may come in the rules. Currently, we have cyber incidents such as including data breaches to be reported to certain within 6 hours. However, we don't have the timeline mentioned in the rules in the Act, and maybe it will come in the rules. Right. And the board has quite a few powers. I think Abilash may talk about it. Is they have to direct the data fiduciary to undertake remedial measures urgently and the mitigation measures. And the board also has the powers to investigate based on the complaint received either by the data principal or an intimation received by the data fiduciary. Now, the extent of the investigation is also very crucial to note. Now, there is, because of the overlap, like you mentioned, Roopa, of multiple legislations that we currently have, till the time it is notified, I think we have to read it together. But right now, till the time it is notified, all of the regulations under the SPDI, under the Information Technology Act, and the certain reportings have to follow as is.
Okay. Okay.
Okay. And very quickly to the other question that you asked on the penalties. Now, the board determines the monetary penalties, but there's an element of discretion, of course, because it's dependent on the nature, gravity, and the duration of the breach, whether it is, how many times has this guy repeated these kind of breaches, and the sensitivity and the type of data. Did someone gain from it? Someone lose from it? Are some of the broad prudence that the board would discuss before they do it. And here is the schedule, right? The scary schedule of what this breach amount, the penalties could be. And reasonable security safeguard, highest 250 crores up, and all of these are up to, so it's a range. And here is something that really disturbs me. So for a data principal, for not performing his duties, which is don't impersonate, don't give false information, don't do frivolous complaints, give correct, authentic information, is a right, is a duty. Okay. And I agree to those. You don't do it, 10,000 rupees penalty, fine. Here is something. If they don't comply to all applicable laws, I mean, as an organization, even an organization which just got incorporated, there are about some 80 legislations applicable. Now, expecting an organization which has a framework, a governance framework, etc., compliance to all applicable laws itself is so difficult. Now, you're asking an individual to comply with all applicable laws. What does that mean? Should I not jump a traffic signal? Or what does that mean? Right? So that's something that is disturbing.
I think whatever I've heard is they've just passed. They made it as simple as possible. There's going to be a lot of amendments. The rules, of course, will come in, legislations. I mean, it's going to be fun. That's all I can say. The lawyers are going to have a field day now in the next few years. Thank you. Thank you so much, Sharda. So I'm going to move on to Abilash. Abilash, if you can just now come and, kind of stitch all of this together, because I know a lot of our participants here must be techies. Can you talk about how India has our techno-legal, how the lawyers and the technical people are working together? I know Sharda briefly touched upon DEPA, but whatever you would like to talk about in terms of how, when putting this legislation together, what did the drafters and the technical people who advised have in mind as to how this whole thing is going to be implemented here?
Absolutely. No, it's a pleasure to be here amidst lawyers and then, speaking tech in front of Thai audience. It's a privilege. So this is a very, very interesting question, right? India is moving towards a $5 trillion economy, and the law has been literally sculpted from a perspective that how can we move in that direction, and different geographies. For example, Europe is sort of known for putting really strong regulations. US, though it's a pro capital, don't have a privacy regulation. They are working on ADPA, which is a federal privacy regulation, but still not out. Primarily US regulations are opt out, while European regulations are opt in. So opt out is a much more lenient way of privacy, while opt in is a much more rigorous way of privacy. Now, India has taken a very balanced technocentric approach, and hence you even see penalty. The topmost penalty, 250 crore, is when you don't implement technical safeguards, reasonable technical safeguards preventing against breach. Now, this has a very deep thought process in it. right? In the surface, they have tried to keep the legislation as minimal as possible, but there is a lot of depth into it. How do you ensure? And then when you look at the definition for breach, it is very, very broad, as just Sharda told now, right? That any unauthorized processing of data, usage of data, sharing of data is considered a breach. So breach is not like how we know in the security world, where the firewall is broken or they have identified ports through which they come into your network and take the data out is called breach. Here, that's not the case. Even within your organization, if you are using the data beyond the purpose for which the consent has been made, and you are using the data, it can be considered as breach. And 250 crore is penalty per instance. It's not total penalty. Per instance of breach, it is considered as a penalty. Now, even if you don't inform, right, within the time frame, once we will get the rule, it will become clear what is the time frame. But within the time frame, if you don't inform the data principals and the board, then there is an additional penalty of 200 crore. So this is really, really huge. And to start on top of it, organizations have to do something called data protection impact assessment if there are significant data fiduciary. So this can become very heavy if organizations don't start doing things in the right way. The advantage of we being in India is that from a DPDP framework, as Sharda was saying, we are on top of a digital revolution in India. Easily, we don't see the benefit of having a UPI or Aadhaar, but when you go to Dubai or US or Europe, you feel like they are in dinosaur era. Hey, what are you guys, man? You are still doing, cash payments and card payments. Okay, where are you guys, right? So we are riding on a digital wave. So this has been structured that way, starting that the foundational layer is identity. Right. This is the brilliance of India stack, starting with the foundation layer of identity. Now everybody is onboarded. On top of this is a platform business model. Now in the West, the big techs do platform business model. In India, the government is doing platform business model, which you should be proud of, right? I would say platform service model. I would say, right? Digital public infrastructure is a platform service model. Now, on top of this, they have built the next layer, which is UPI, which is for transaction, which once again touches everybody. Now they have put a identity layer, that they have put a finance layer. What next is the question, and which we have built something called DPDP, which is data empowerment layer for the citizens. And now they are building all services on top of it. For example, Ayushman Bharat Digital Mission or National Digital Health Mission, right? Which is connecting lakhs of hospitals, primary, secondary, tertiary care hospitals in the country. It's going to be integrated into this National Digital Health Mission or Ayushman Bharat Digital Mission. If you look at ONDC, once again, an amazing concept, right? Which is integrating all, marketplaces, including mom and pop shops to delivery agencies to payment services to everything together. Now, these are population scale, data ecosystems. And they are going to connect APIs and then leave it so the ecosystem can grow. Now, the data which is going to be generated out of it, think of healthcare data, right? If you put all, let's say, 5 lakh hospitals in the country and get data out of it, this is like super, super sensitive data. And how do you, and this data can create wonders for the country, make insurances very, very cheap, right? Because insurance agencies now can predict much easily, the cost of a disease and where it is going to happen and things like those. Deliveries can happen, identifying points of delivery and things like those can become very, very predictable, which can once again reduce supply chain cost. So these are all very, very powerful platforms which can improve the efficiency of the whole economy at the population scale. But the challenge is data. Even from every layer, starting with Aadhaar, Doraswamy judgment is primarily was for the Aadhaar layer, which is the foundation layer, right? That's where we got privacy as a fundamental right. So for all these population scale initiatives, privacy is the fundamental problem. And the power today's startups have in their hands is that they can ride on these platforms, which means you can directly get access to 1.4 billion people's data, right? Once these DPDP layer is opened up, right? Let's say ONDC, right? It can open up the entire e-commerce layer, and then open data, if it is made available on top of it, it can make the whole data available for a startup. Similarly, account aggregator ecosystem, today it's being used for, transacting account information. But if open financing happens on top of it and then allow financial data to flow, it can suddenly unlock financial data for, model building and things like this, which can unlock the whole banking industry. So that is the kind of disruptive thought which is going on. And one of the fundamental requirements, hence, is privacy, techno-legal privacy, because population scale data gets breached, right? Think of a startup having all transactions of everybody in the country. It is really scary, right? So controls have to be in place, and startups also need to, with a lot of power comes a lot of responsibility. So organizations need to put in place the right amount of control. Hence, if you look at significant data fiduciary, it is not with the revenue of the company, but the volume of data that the company has. So even if it is a startup, but it has access to huge volume of data, then it will be considered significant data fiduciary. That is at least the understanding as of now. So they have to, but if they play this game well, sense like if they put the right technical controls in place, then sky is the limit. You can get huge amount of data, and then you can create huge value. With value and privacy, you can get a lot of trust. Look at Apple today. Just go to airport, all the Apple boardings would say privacy, right? Because everything else is in today's market is commoditized. If you look at camera, a Chinese company can put a better camera than Apple. Display, somebody can put a better display. The soft feature, especially privacy, is becoming a very fundamental differentiator, strategic differentiator, and it's not a cost center anymore. It is a profit center, because you can create digital trust out of privacy with technical safeguards. So that's what is happening. So while the law is very, very complex, if organizations can connect this as strategic insight and data as strategy, they have the right data governance in place, data strategy, and right technology and process and people in place, this can be a differentiator not just in India, but at the global scale.
So for a layperson like me, am I looking at like a privacy gateway, just like a payment gateway? Like if I'm a startup and I need to put a payment gateway, I don't need to do everything myself. So are we looking at a privacy gateway? Is that what it is? Just a loose
sort of.
Or did I just give you an idea?
Yeah, sort of. So there would be like security, right? Security is a spectrum. You have starting from firewall, antivirus, anti-spam. There are so many products in privacy. So similarly, privacy in security, right? Similarly, in privacy also, it's going to be a spectrum of products, because data itself is a spectrum, starting from PII to mass to pseudonymous to anonymous to synthetic data, right? So this is a spectrum, and with generative AI coming in, that also adds to the synthetic spectrum. So when this is a spectrum, organizations are going to have assets. Data is an asset, right? They are going to have the spectrum of assets, starting from PII to masked assets to pseudonymous data assets to anonymous data assets to models to synthetic data assets. And different levels of assets will have like portfolio, right? Different levels of data assets are going to have different levels of risk. And today, primarily, organizations have very, like how traditionally people only invest in gold if they make investments like centuries back. Today, people only have the PII as data assets, PII or masked PIIs, right? But going forward, organizations are going to build this portfolio of different flavors of privacy preserved data. And when they have it is when they can truly unlock value out of data and go global.
So what is the technology? Like for example, will technology now allow you to detect breach and report it? Will you store it? Like at what level are all these different startups, different ideas that the stack is going to now enable? And also what happens to pure play startups, which just like businesses, forget the startups, just businesses who are starting off. Now, I was just teasing somebody this morning, earlier we had those hand register. In Karnataka, at least Shops Act, we still need to have the hand register. That's a good thing, because I believe that doesn't even apply. This act is very clear. It's only Digital Personal Data Protection Act. So your stuff that you have in your old accounts notebook is not covered by the act. So we'll have to go backwards now, right? So all those fancy photographs after you enter the premises, people maybe they have to start rethinking all of that.
Absolutely. So two very important things, right? One is understanding the risk. Second is mitigating the risk. As simple as that, like cybersecurity or even legal, right? You understand the risk of doing something and ensure that you mitigate the risk or put controls, safety controls around mitigating that risk.
Okay.
Once you understand this, things will fall into place. So this is a journey. Privacy is a journey. Nobody can do it in one click. It's a journey. Organizations have to build it over a period of time. But if we are, the moment we are conscious, there are some very fundamental principles of privacy. For example, data minimization, purpose limitation, storage limitation. These are very fundamental principles of privacy. So anybody building, as you said, it doesn't apply when you are writing in pen and paper, right? That's a good thing, right? Mom and pop stores, you cannot ask them to do all these things, right? But when you look at large organizations or even large startups, what is very important is how you should not get all data that you can get your hands on. It's a very bad behavior, because data can become a toxic asset as well. So only get data that you need to serve, right? Only use the data as much as you want. If you get more data, put corresponding protections in place, then you will most probably be covered.
So are you saying now that lead generation through buying data packs, data, people who've generated data and putting into HubSpot, is sales going to change completely? I know that's for a different thing, but you already just touched upon it. So I need to just ask you this question. And you're a CEO of the company.
In fact, there is a company called, company, European company who are a customer. It's a customer data platform, CDP. So they are a privacy first CDP, right? Think of it. So
I know we're going to have another session on this, guys, tie itself through tie. So I don't want to take away the thing. But since you touched on it, you're saying, so somebody else said the whole model is going to be questioned, but you're saying, no, we're going to actually find a solution using technology and business practices. Super. So that's lovely. So I have 8 minutes more. I have several questions. Before I want, because I know we're going to get cut off at some point. There's one question that came up twice, and that's about gig economy. I just want to raise that again. Sharda didn't have the time to answer that. Stephen, anybody else? So this is basically the question is, in the employer-employee situation, what happens to gig workers? I have some thoughts on it, but if any of you have any thoughts, otherwise I will go for it.
So when it comes to employment, we have to look at employment law. And a gig worker is not an employee. A gig worker is a contract. He's an independent contractor. Therefore, the exemption with regard to employment that applies in the Act will not apply for a gig worker. That's the answer.
Yeah, but Stephen, there are laws. I'm not kept track in the recent past. But for example, there are laws in terms of aggregated, in different parts of the US state where they've given rights depending upon how your contract is. And if, for example, if you don't have any other choice, then you have to be part of the platform, and it's almost your full-time job, right? So can you be termed as an employee? So these are things that hasn't evolved in India, but could, right, at some point. So I agree with you. If you're able to show somebody is a completely independent contractor, then it may not come here. But the reason I'm bringing this up is because I'm a gig player. So I'm very curious to see how this particular aspect of the law comes through. I know you can't say I'm an employee, I want benefits. At the same time, say, I want my intellectual property because it's mine. So that law is just evolving right now.
I would also say here, Roopa, that when you're looking at benefits, you might take a more liberal and expansive view. But when you're looking at an exemption to an employer, you would more likely to take a strict view.
Very good. Very valid.
I think it's going to be very hard for a gig platform owner to take the view, these people are employees, therefore I'm covered by the exemption.
Valid point. Absolutely. I hope you got your answer. Yeah. So, Stephen, you had a few thoughts on, right to deletion. Would you like to expand on that?
Yeah. So I noticed there were quite a few questions on that, and I think there's some amount of alarm that I can detect about right to deletion. So I think there are two overriding principles, because there are 3 situations in the Act, and the provisions on each are slightly different. But by and large, there are two overriding principles. The first one is the purpose for which you collected the personal data. Is that purpose still being served? That's the first question. And the second one is there something in the law that requires you to keep that personal data? And if the answer is yes, then you still need to keep that personal data. So let's say there's a payment involved. A payment involved may require you to keep payment information under the Income Tax Act or under the Companies Act. Then you still need to keep that information. There was someone who asked a question about a taxi driver on Uber who misbehaves and who's taken off the system. And then he writes to Uber or the platform owner and says, please delete my data. So the question is, should they delete it or not? I think here one has to look at the principle behind the law. To my mind, there's an issue here relating to security. If you delete the data, then his record of misbehavior will go away, which means he could be rehired. And so on that ground, a platform owner like Uber or Ola could decide that no, the purpose for which we have collected this data, especially the information about the misbehavior, is still being served because we need that data for security reason. And so they would not delete it. That's my initial kind of thinking aloud answer.
Probably I'll quickly like to add on to
Yes,
it,
please. Yes, sir.
technical angle to it, right? So there are a lot of scenarios where the data need to be, because purpose is very, very strict. For example, it says that if you're booking a restaurant, once you have had your dinner, the restaurant has to delete your phone number, right? Or your preferences and things like those, right? But this information would be very important for managing the supply chain, how to plan for the next day and things like those, right? So one of the techniques, because it's a techno-legal framework, one of the very important solutions, technical solutions, is to anonymize the data mathematically. There are anonymization, once again, is a very abused term. So there are technologies like differential privacy, etc., with which you can anonymize, through which re-identification is mathematically prevented. Once you do that, you can still understand the persona level information, like, okay, these kind of people coming with these age group, these blocks, require this kind of, had ordered these kind of food. That is possible, but re-identifying exactly who ordered what will not be possible. Thus, this data becomes from personal, it becomes non-personal, so that this data you can retain further, starting from GDPR across the globe. This is the norm. So when you anonymize it, you can still use it for model building. Thus, India can, Indian businesses can still create a lot of insights without actually violating personal information.
Great. So we're almost time, but I'd like, and I know we didn't go through all the questions, but as you know, folks, we are going to have more of these sessions. So please log in. Maybe Stephen and Abilash will join again. Or maybe there'll be other people. But as and when you attend more of these sessions, we'll all be able to solve more issues, and maybe something will go to the government, and they'll be thinking about all these issues too. I'd like to open this up to both Stephen and Abilash for last comments. If you were to give one advice, Stephen, to the startups here, just one gyan, free legal advice from a senior partner of a large firm. Can you please give it? Happily take it and come back to you if you have more questions.
So what I would say is that there's a very clear roadmap that all businesses need to follow. And it's better to start down that roadmap as soon as possible. So the first question is, what personal data do we need? And once you have a law that comes in like this, the best option is to collect as little as possible. I know there are many people in the business who may not like that answer. Then you move on to, how do we manage this personal data? You have to have systems in place that track it and ensure that all the different stakeholders within your company, whether it's the business development, whether it's marketing, it's sales, it's accounts, it's HR, all of them, you're controlling that data, so it's just not going all over the place. Because the last thing you need is for someone to come and ask you, where's my data? What data of mine do you have? Or then be hit by a grievance that goes to the Data Protection Board and investigation, and then a penalty which could hurt you financially, but will hurt you even more from a reputational standpoint. So I think there is a roadmap, and you need to go down that roadmap. The second thing I would say is, more jokingly, you probably need to hire a lawyer.
Yeah. And now lawyers are going to also in-house have been the DPO till now. So Abilash, for you the question, do you think we'll continue to hold that job, or are you going to now give it to the CISO?
No, this is a very, very much legal area, right? So lawyers will have a very, very important role. Probably, we forget lawyer or CISO. We are looking at, human beings evolving into something like, a new species with putting, Neuralink in your brain. That's where we are going. So this is going to get into very, very interesting areas.
So your two thoughts, Abilash, if you can just, I know you've given us some stuff, but closing comments.
Yeah, absolutely. So looking at businesses should look at it like this. Okay, look at Apple and Facebook. You respect Apple more than Facebook, especially with privacy bill coming and all. Facebook stocks took a beating, right? And Apple is like soaring. So the future is about digital trust. The more you do business the right way, customers will have more trust, which will create more value. They will voluntarily give you more data if they have trust in you. More data, you can create more insights, more value, which will once again create a cycle of more trust, right? So what I would recommend is, like, if you follow there is no other option, right? Follow the regulation wholeheartedly, put the necessary technical legal controls in place. If you build the right data strategy, focusing on digital trust, believe me, this is going to be a strategic advantage for your business.
Thank you so much. So as a closing comment, so we have the roadmap, as Stephen says, out there in the law. We might not have had all the nitty-gritties, but it's time to start thinking through this, right? Don't wait for 6 months later, because it's right from now that we start respecting what we have, and collecting it right, and start getting information about this. With that, I'm so sorry, guys. We have to wind up now. But I really appreciate Sharda, Stephen, and Abilash for giving their time. They're all very busy people, and I really appreciate Ty appreciates, and thank you, Ty, for this opportunity. Vinay and everybody else who made this happen. I hope to see you all at the next session that Ty will be organizing. Please stay connected for the next session details. And that's about it. See you soon from Stephen Mathias, Abilash Soundararajan, Sharda, Balaji, and Roopa, and Vinay Dora. Thank you.
Thank you.
Bye-bye. Vinay, all yours.